Senator Blackburn.
Thank you, Mr. Chairman. I appreciate Senator Sullivan's work with us on this. He and I have discussed this amendment and his desire to move forward his legislation, which we all voted for in committee and we voted for when it was on the floor. And he has my commitment to continue to advocate as we build out a broader kids' online safety package with including some of the bills that we're going to pass today, but to advocate for passage and inclusion of his bill.
Thank you, Senator Blackburn.
Thank you, and I will echo that sentiment. Senator Sullivan's amendment is a good amendment. It is a positive amendment. As he rightly noted, it has passed this committee previously. It has passed the Senate previously, and I am happy to work with him to try to get it passed and signed into law because it would be beneficial to the people of Alaska and to people all across our nation.
Thank you, Mr. Chairman.
If there is no further discussion, the question is on Senator Cantwell's motion. All those in favor say aye. 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 All those opposed say no. The ayes have it. The motion is agreed to, and the bill is ordered to be reported favorably.
Mr. Chairman,
Senator Lummis.
I would ask that we give permission for those parents of children who have been lost because of online activity to just stand up and tell us their child's first name so we can acknowledge and honor the loss that these families have experienced and to express to them our deepest sorrow for your loss and our desire to move forward with legislation to prevent other parents and family members from dealing with the pain that you all are dealing with.
I think that's a good suggestion, and if the parent advocates wish to do so, you're certainly welcome to do so now. Thank you, and we honor your children's legacy, and thank you for using the pain and agony and suffering that you've experienced. Thank you for channeling it into trying to protect other kids. Thank you, Senator Lummis. I recognize Ranking Member Cantwell for an additional motion.
Mr. Chairman, I move that S 4199, the Youth AI Privacy Act as amended by the Markey substitute as modified, Bud 1, Lummis 1, and Lummis 2 be favorably reported.
Is there a second? Is there any discussion? I'm going to offer Cruz 1 as modified. This amendment is straightforward. It would empower parents to make decisions for their children. Although I appreciate Senator Markey's work to improve this bill, one significant problem remains. The bill imposes a one-size-fits-all limit on how long a chatbot may remember its interactions with a child, capping overall memory retention at 30 days. A default period for memory retention makes sense, but parents must also be able to choose a different period or opt out of automatic deletion. Long-term memory can make these tools more useful in certain circumstances. For example, when a child is learning a language or a teenager is managing a small business. At the very least, the federal government should not forcibly substitute its judgment for that of parents. My amendment preserves both the default and parental choice, and I urge my colleagues to support it.
Mr. Chairman?
Senator Markey.
Yep, thank you, Mr. Chairman. First of all, I just want to thank you and Ranking Member Cantwell for your work to help to protect kids online and for your support for advancing my Youth AI Privacy Act, the YAP Act, and I can't thank you enough. And to all of the family members who are here, we're just so sorry for your loss, just absolutely terrible. And that's why we're meeting today, for you. And I appreciate the chairman's work with me, but on this amendment, I do oppose it. The Youth AI Privacy Act, as originally introduced, directed the Federal Trade Commission to establish limits on how long an AI chatbot could use a minor's personal data to shape its responses. Those limits prevent a chatbot from endlessly drawing on a child's responses to personalize future conversations. Extended, highly personalized interactions can deepen a child's emotional attachment to a chatbot and make safety safeguards less effective. As part of our substitute amendment, I agreed to remove the Federal Trade Commission rulemaking and allow a parent, through verifiable parental consent, to extend the memory period up to 30 days. This amendment would remove that 30-day ceiling. The amendment would permit the ongoing use of a minor's personal disclosures about relationships and fears and health, emotional state, and vulnerabilities to shape future responses without a meaningful outer limit. The companies will have every incentive to push families towards the longest possible setting by marketing it as more convenient, more personalized, or necessary for the chatbot to truly know the child. The 30-day limit is a reasonable guardrail against effectively having a permanent memory for minors. I urge a no vote, but I say that, saying that I would also be open to a continuing discussion with the chairman on this issue, but for this moment, I would urge a no vote.
Is there any further discussion?
Mr. Chairman, just speaking in support of Senator Markey's position, the longer kids interact with the chatbot, the more data the chatbot can collect, the more manipulative the chatbot can become, and I understand that 30 days may not necessarily have been the perfect day, but allowing unlimited chatbot memory is too dangerous, and so I support Senator Markey. I want to say that the parents' groups also support Senator Markey in opposing Senator Cruz's amendment.
Thank you, and I think that point is generally correct, but I also think that parents know their kids best and ought to be able to make decisions for their own children as appropriate for their kids. If there's no further discussion, the clerk will call the roll.
Mr. Thune?
Aye by proxy.
Mr. Wicker? Mrs. Fisher? Mr. Moran?
Aye by proxy.
Mr. Sullivan? Mrs. Blackburn? Mr. Young? Mr. Budd? Mr. Schmidt?
Aye by proxy.
Mr. Curtis? Mr. Marino?